Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss two cases with the same title. One is happening in 2017 and another is being decided in 2018. One is Justice K.S. Puttaswamy, retired Justice K.S. Puttaswamy, and another versus Union of India and others. And another case also goes by the same name. But in 2017, a 9-judge bench is basically looking at the law question that whether right to privacy is a fundamental right enshrined in the Constitution of India. And based on this 9 judges' judgment verdict on right to privacy, this case number 48 is being decided in 2018 by a 5 judges bench. Okay, so now this 2018 case is specifically dealing with the constitutional validity of the Aadhaar Act that has been passed by the government, and this particular case number 43, which is 2017 litigation happening in Justice K.S. Puttaswamy versus Union of India, is basically looking at the question that whether right to privacy can be said to be a fundamental right in the Indian constitutional law, right? So we will start with the 9 judges bench decision that is coming in 2017 in the case of retired Justice K.S. Puttaswamy. Now, what is happening in this case? Basically, the petitioner herein, as the name goes, is a retired High Court judge, and Justice Puttaswamy is basically questioning the biometric data collection by way of welfare schemes and calling it a violation of privacy. Now, the moot question that is arising before the bench in this case is that whether right to privacy is a fundamental right. Can we hold right to privacy as a fundamental right under Indian Constitution? Because the previous judgments that were being decided in MP Sharma as well as Khadak Singh in 1954 and 1962 respectively, that says that right to privacy is not an inherent right in the part 3 of the Constitution of India, as nowhere privacy is mentioned, right? So now when we come to this case, when we come to the case of Justice K.S. Puttaswamy happening in 2017 before the 9 judges constitutional bench, the question is whether right to privacy is a fundamental right under Indian Constitution, and if it is, then under what article, and by extension of what article, by interpretation of what article can we read it in the fundamental rights? So petitioners herein are arguing that privacy is an inalienable part of personal liberty, right? And it flows from Article 21. But however, the government herein is, saying, the Union of India, the respondent herein is relying upon the set precedents in the case of MP Sharma and as well as the Khadak Singh, saying that Constitution does not explicitly recognize privacy as a fundamental right, and therefore it cannot be read into the interpretation of the Part 3 of the Constitution of India. However, in this case, the bench, 9 judges bench, unanimously agreed to the point that right to privacy is a fundamental right which is protected under Part 3 of the Constitution of India. Now, the courts herein are expounding, saying that right to privacy is not a single right, but it is a collective bundle. It is a bundle of rights dealing with integrity and autonomy of individuals. Now, key holdings of this cases goes like that: privacy is intrinsic to dignity and liberty under Article 21 of the Constitution of India. It also finds its root in Article 14 as well as Article 19, right? That I have the freedom of expression. It finds its roots in the freedom of expression as well. It finds it in the it finds its importance in the equality. It finds its roots in basically mainly majorly dignity and liberty. So now court herein is also saying that privacy is not an alienable right, that you can read privacy in isolation. Privacy includes bodily autonomy, it includes self-determination, and it includes decisional autonomy in intimate matters as well. Now, what courts herein are saying is that privacy, even though we are recognizing it as a fundamental right, it is not an absolute right, because even if we look at Part 3 of the Constitution of India, they are subject to reasonable restriction, they are subject to reasonable qualifications. Now, court herein is laying down threefold parameter test to say where where privacy is a fundamental right, is in absolute form or non-absolute form. Now court herein is saying that privacy is not an absolute right. It is subject to a threefold test, that there can be invasion of privacy if there is a necessity, if there is a proportionality arising, and if the law that is, if the law that is allowing invasion of privacy, it is sanctioned by law and it is necessitating the reason, it is a proportional reason that why there is an invasion of privacy, only then there can be an invasion of privacy by an act which is backed by the law. But however, privacy was recognized as a fundamental rights. Now, this judgment is also emphasizing a constitutional basis for challenging state surveillance, data collection, and also further, digital governance regime. It is the product of this judgment that now we do have a DPDP Act. We are moving towards the framing of a Digital India Act. But when we are talking of bodily autonomy, when we are talking of privacy in this case, we are also looking at another cases that are happening. Naftage, Joseph Shine, and in fact, the second litigation case, Puttaswamy 2 judgment, which is the Aadhaar case we know as, even those cases are premised on Justice K.S. Puttaswamy 2017 judgment, which is bringing out that right to privacy is a fundamental right. So that is also being relied upon by the Naftage judgment. Naftage, we have already discussed that even that all the genders do have a right to privacy, they do have a right to their sexual autonomy, and that argument of privacy is flowing from Justice K.S. Puttaswamy's judgment only, which was being adjudicated in year 2017. Now moving on, 2018 judgment comes as an aftermath of the 2017 judgment being decided by the 5 judges bench, namely Justice Deepak Mishra, which was the then CJI, Justice A.K. Sikri, Justice Khanwilkar, Justice Chandrachud, and Justice Ashok Bhushan. This particular judgment, it is examining the validity of Aadhaar Act, right? So the main moot question revolves around Aadhaar targeted delivery of financial and other subsidies, benefits, and services Act of 2016, and the constitutional validity of this act is being challenged. So 5 judges bench is adjudicating the matter, and the question in herein is that whether the Aadhaar Act of 2016, does it violate the fundamental right to privacy? Is it constitutionally valid? And another question revolves around the money bill aspect, because this Aadhaar Act was passed as a money bill under Article 110. Now, when a money bill is passed, it is passed by Lok Sabha, right? There is no involvement of Rajya Sabha, and Rajya Sabha's involvement can be done away with also if there is a proposal by the Lok Sabha, right? So now in this case, what is basically Article 110 clause 1 provides us that a money bill can only contain provision that deals exclusively with taxation, with money, with consolidated fund, with contingency fund, with appropriation of fund, and with any kind of funds that are, incidental to consolidated fund or contingency funds, as we are discussing above, right? So now herein the question arises that when Aadhaar Act is being passed as a money bill, because only Lok Sabha can pass a money bill and the Rajya Sabha's role is advisory, it is not binding. So it is being passed as a constitutional fraud because it is wrongly passed as a money bill. It is bypassing the procedure of bicameral scrutiny, which is raising serious, institutional concerns with respect to Constitution of India. So the main question, the two main questions that are arising, whether it is validly passed as a money bill, and secondly, whether it is a violative of fundamental right to privacy or not. Now, majority opinion is holding in this case that Aadhaar Act is serving a legitimate aim, which is targeted delivery of welfare. And Section 7 of the Act is basically requiring Aadhaar information for subsidies from Consolidated Funds of India, which is also a valid one. And it was found that the architecture, the institution of Aadhaar Act was secure with sufficient safeguards, right? Now, Aadhaar requirement for, having mobile SIMs activated, etc., and getting admissions in educational institutes, etc. These were, you know, rejected, that you do not need Aadhaar card for private institutions as well. So Section 57 of Aadhaar Act was also struck down in this case, saying that private entities cannot use Aadhaar card for authentication because the data can be collected, and the data surveillance and data mining, things like data mining, becomes a raising concern if such things happen. So Aadhaar's validity was upheld in this case. It was upheld that, you know, Aadhaar is not Aadhaar Act is not an invalid act. The the validity was upheld. It was not held that it is, you know, acting in privacy, because when we were discussing the 2017 judgment, we had a discussion on the fact that when when there when there when the law meets the necessity, when the law meets the proportionality, then in that case invasion of privacy is allowed to the extent it is proportional to the law that is providing its you know, its invasion of privacy. Now, herein it was held that this particular act, the Aadhaar Act of 2016, is valid. It is not violating a fundamental right to privacy. 57 was struck down, where Aadhaar was used for private entities, holding it unconstitutional. And it was held that for, you know, procuring mobile phone connections, or for, you know, even opening a new bank account, etc., Aadhaar card is not required. But in this case, the court is also saying that for income tax purposes, for tax collection purposes, we cannot hold that Aadhaar PAN linkage is invalid. So court is seeing a reasonable nexus when Aadhaar PAN linkage is coming in question, and it is also holding it valid for the purpose of taxation laws, of course. So in this case, this one question was decided that Aadhaar Act is not invalid, as so far as it does not infringes into the privacy, and even if it is infringing into the privacy, it is done for a reasonable nexus. But when we come to the second question, money bill, now there is a diverging opinion. Justice Chandrachud is criticizing that, you know, this particular Aadhaar Act is being passed as a money bill is a constitutional fraud, whereas the majority judgment is saying that it is not wrong to call this bill as a money bill, because the bill is providing for subsidies. Section 7 of the act is providing for subsidies and benefit. That the bill, ultimately the bill is titled, if we look at the bill, it is titled as Aadhaar Targeted Delivery of Financial and Other Subsidies, Benefits and Services. So there is a financial element here. When we are, you know, invoking subsidies, we are actually using the consolidated funds of India, the funds of government, and therefore it is appropriate when this act is being passed as a money bill. So automatically the Aadhaar Act was upheld even when it was passed in the garb of money bill. That was also upheld. However, there has been a sheer criticism of, you know, using money bill, the provision relating to money bill for implementing Aadhaar Act was called as a constitutional fraud by Justice Chandrachud. But however, the act was upheld, and it was ruled out that the main objective of the Aadhaar Act is to deliver subsidy, and other provisions are incidental to this core object, right? So this was validly passed as money bill. The opinion was upheld, and this was the case of Justice K.S. Puttaswamy versus Union of India, specifically 2017 and 2018 litigation. Now, herein one important thing is that Justice Chandrachud is delivering the dissenting opinion in this case on both the issues, criticizing its, criticizing its implementation in the form of a money bill, and also expounding the idea that Aadhaar is enabling mass surveillance, and according to him it is not also, you know, falling in the proportionality test, also violating the autonomy of the individual. So this was he was also criticizing that the procedure bypassed the bicameralism, which is a mandate by the Constitution of India, and therefore with the dissenting opinion of Justice Chandrachud, the majority opinion is holding that this particular act is valid and it stands on the constitutional validity. Further, these two litigations led to the formation of Digital Personal Data Protection Act 2023, which we also call DPDP Act, which is actually a legislation that aims to, you know, operationalize or channelize data privacy rights. Now, there are UIDAI guidelines which are also restructured. There are private companies, private entities which do not mandate Aadhaar information for services they are providing. So this was some implications, impacts of this judgment. I hope the discussion was useful to you. Thank you, everyone. Please stay tuned with us on Legal Darshan. Stay tuned. Keep watching. Thank you, everyone. Have